Hi, everyone. I'm Audrey G. from Brown, G. and Wenger. I am a civil litigator and do a lot of class action defense and employment law. And then we are here today, and thank you to the CCBA and ADR Services and JAMS to talk about civility and what does it mean. And everyone actually is listening. And the core of your profession is civility. All right, so just really quickly, I'll do a quick agenda brief so you'll have a roadmap, and then I'll do some introductions of our wonderful panel, and then we will go ahead and get to the meat of it. So agenda, really quickly, we're going to talk about the new Rule 8.3 on reporting professional misconduct, and then we're going to talk about the importance of being civil and maintaining your reputation and good health, law firm culture, and its impact on civility, as well as working for other offices. Unconscious bias, how we treat opposing counsel, clients, colleagues, and others in the legal community, and micro cues, recognizing how word choice, body language, and body awareness can create more civil interactions. And then last, our responsibility to our community and why civility matters outside of our courtroom or in your legal office. All right, so let's turn it to our esteemed panel. We have with us Judge Steve Austin, who you all know and love, served 23 years as judge of the Superior Court for Contra Costa County and is now a neutral with ADR Services. He worked primarily in the civil department with additional assignments in family law and criminal trials. He's become widely renowned for proactively and successfully settling his cases, conducting close to 1,000 settlement conferences over the course of his judicial career. He's also served as civil supervising judge of the Pittsburgh branch, PJ, and assistant PJ, and helped launch Community Homeless Court in 2008. His honors include the Lifetime Achievement Award from the CCBA, Trial Judge of the Year by the San Francisco chapter of ABOTA, and twice by the Alameda Contra Costa Trial Lawyers Association. And prior to his judicial career, Judge Austin was in private practice for 17 years, specializing in personal injury, civil rights, insurance coverage, and CD litigation. He's a baby Bruin from UCLA with a BA in Communication Studies and his JD from Hastings. We're also so pleased to have Judge Barry Baskin, who serves as an arbitrator, mediator, special master referee, and neutral evaluator at JAMS after 20 years at the Contra Costa County Superior Court in almost all divisions of the court. He was also presiding judge during the pandemic. Thank you so much for getting us through that very tough time. He served as assistant presiding judge on the court's executive committee, and his last assignment on the bench was a second term in civil division, where he handled complex litigation, construction defect, class actions, and a variety of other matters. He was the first person appointed to the bench in California who was born, raised, and trained in South Africa. Judge Baskin's honors include Trial Judge of the Year by the Alameda and Contra Costa Trial Lawyers Association, served on faculty to teach new judges at their orientation, and continued to do so until he left the bench. Prior to his service on the court, he was a civil litigator with his family law firm, his family's law firm in South Africa, and also at Pillsbury Madison Sutro in the antitrust and IP group, and then at his firm of Farrow, Bramson, Baskin, and Pletznick. Judge Winifred Smith is with ADR Services after having served 21 years as a judge of the Alameda County Superior Court and 26 years as Deputy Attorney General. Judge Smith presided over civil law in motion, civil direct, and complex litigation matters, served as a member of the Judicial Council, supervising judge of multiple courthouses, supervising judge of the court civil division, and presiding judge. In her civil cases, she handled class actions, employment, oversaw construction defect, and also Prop 65 matters, presided over nearly 100 cases to verdict, including a product liability and complex litigation case, which resulted in the largest civil award in California's history. Prior to that, she served as Deputy Attorney General, and her honors were a Jurist of Distinction by the Women Lawyers of Alameda County, and also Trial Judge of the Year by ABOTA. So we have an amazing panel for you today. Thank you, judges, for being here. We really appreciate the work. And of course, Judge James also did the work as well. We're very sad that she can't be here. But with that, we're going to go ahead and move to Rule 8.3, the California Rules of Professional Conduct. This is a new rule reporting professional misconduct. And Judge Baskin will go ahead and discuss this new rule with us. Judge Baskin.
Thank you. Thank you, Audrey, for those remarks. Welcome, all of you. Good afternoon. It's a privilege to be here and to have the chance to talk to you about this sea change rule that, in my opinion, does represent a sea change. I think the drafters of this rule must have convinced themselves that civil litigation was rapidly becoming uncivil litigation, and this rule, I speculate, is calculated to address that. You have it up there on the screen, and I'm not going to read it to you out loud, but I recommend for those of you who have not already read it, that you take this opportunity to read it. It does give you a mandatory obligation, and you'll see that word shall there. It's quite clear that you have no option, but without undue delay, you must inform the state bar or other tribunal whenever a lawyer knows of credible evidence that another lawyer has committed a criminal act or has engaged in conduct involving dishonesty, fraud, deceit, or reckless or intentional misrepresentation or misappropriation of funds or property that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer. Now, on the face of it, that seems to be a rather broad rule, and I'm hoping that the state bar authorities have ramped up their investigators, because if it's anything like the judicial reporting rule that judges have for decades been under, it is going to really raise the volume of complaints that they receive. There's no question about that. The rule is broad enough that it could arguably take into account almost anything, and it's not limited, in my opinion, to things that you witness from opposing counsel. This rule just refers to any other lawyer. That could refer to somebody within your firm. It could refer to counsel that you're working with, co-counsel that you're working with. It can extend beyond just the normal litigation scenarios that we're all familiar with. I want to remind all of you that for decades now, long before this rule came about, judges are under a much broader obligation. When I first became a judge, I was surprised to learn that a judge has an obligation that whenever a lawyer has committed misconduct or violated the rules of professional conduct, that the judge is under a similar mandate. The judge shall take appropriate corrective action, which may include reporting the violation to the appropriate authorities. And so it's not a choice that a judge has. A judge must take corrective action whenever this type of behavior is brought to the judge's attention, usually in motion proceedings, usually at hearings, sometimes at trial, sometimes during jury selection. But whenever it comes about, a judge must take appropriate corrective action, and the judicial reporters, that the annual report that comes out from our CJP every year is filled with the incidents where judges have failed to take appropriate corrective action or failed to report it to the CJP. So I'm thinking that this is a similar type rule. Its parallel is this Canon 3D of judicial disciplinary responsibilities. And I think it does clearly raise the bar and puts all of you under an obligation that if you fail to report this conduct, you yourselves could be subject to being disciplined by the state bar. So I think that's all that I'm going to say at this point, and I'm going to open myself up to any questions that you, Audrey, might have at this point.
Sure. So, Judge Baskin, you referred to the already existing obligation on judges, and that seems to talk about misconduct, which is what well, let me ask it this way. What's the difference between the new rule, which is affecting the attorneys, as compared to and contrasted to the existing one that's effective for judges?
Well, I would say that there isn't, as a practical matter, there isn't much of a difference. Semantically, when you look at the two rules, there is a great difference because the reporting of professional misconduct, Rule 8.3, defines it as a criminal act or acts involving dishonesty, fraud, deceit, reckless, or intentional misrepresentation. But I think when you look at the overall impact of the wording of that rule, I think it matches the intent and perhaps the spirit of the canon, which refers to any misconduct or any violation of the rules of professional conduct. And I think that there may be some overlaps, there may be some extra things that are crafted into this Rule 8.3 that are maybe not present in the Canon 3D. But the point is, as a practitioner, you are subject to this much broader rule that is clearly very far-ranging.
Right. It looks like there's scrutiny. Us practicing attorneys should realize there's scrutiny now, not only how you behave in court, but also whenever you're under view by any attorney at all. Certainly, I would think that with the obligation on the bench, it's talking about attorney misconduct, but that's what the bench is going to be seeing when we're appearing in court. But this new rule really talks about dishonesty, fraud, deceit, not only just the criminal act, but, a much broader situation. So again, just to kind of clarify it, if we ask, explain your understanding. If counsel has a personal knowledge of another attorney committing a criminal act, what is that attorney supposed to do?
As I read this rule, the attorney must inform the state bar, or depending on what the nature of that is, perhaps the AG or perhaps the deputy district attorney's office. It will depend on what it is, but that you have without delay to inform them. So that obligation is clear. And as you correctly point out, it's not limited to courtroom behavior. This is referring to correspondence, emails that you write, depositions that you conduct, pleadings that you file, discovery responses that you could be filing, all of the above.
Does it have to be tied to professional conduct? I mean, when you're talking about discovery filing, does it have to be just dishonesty that's tied to that professional conduct, or can it be personal conduct, right? That in terms of someone that goes to the question of the lawyer's honesty or trustworthiness?
Yeah, that's a good question, Audrey. And I think if you look at the tail end of Rule 8.3, the answer to your questions found there, that it's not limited to just your professional behavior. It's limited to anything that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer. So, it might be something that you post on your social media. It could be something that's outlandish, right, that you Twitter.
So if an attorney is involved in their own divorce, perhaps, or and is maybe being dishonest in terms of what they're representing to their former spouse or soon-to-be former spouse, or if they've lied about maybe having gambling debts or something embarrassing like drug addiction or mental health issues, is that going to trigger a duty to report if you know about it personally?
I think a literal reading of this rule is yes to your question. Yes, it does trigger that.
Okay. And so again, I think you answered this. And I was going to ask, is it limited to just opposing counsel? And I think you'd said no, broadly. It's really just another lawyer is the actual language. So for an example, like what if you're a baby lawyer or a more junior lawyer and you see your partner not producing all the documents in a matter or not producing a piece of evidence, or that partner is using it what the associate is maybe considering a thin privilege objection, but that production of the piece of evidence is harmful to your client. What are you supposed to do if you're the junior lawyer?
I think that raises some very tricky questions as far as this question is concerned. And your hypothetical introduces another layer that's perhaps for a discussion on another day, which is the attorney-client and work product privilege. So obviously you cannot cloak misconduct and criminal conduct, of which suppressing relevant evidence could fall into that category. You cannot use the privilege to shield that behavior. But I think, if you are the junior attorney in that position, I'd be very leery about reporting that conduct, because you, as the junior attorney, might be waiving an attorney-client privilege by making that report. I think you might be well advised to rather do a memo and express your views and suggest something to the senior partner, so at least your position is documented and you've made your position known that way.
Thank you.
Hi, Audrey. We have some questions from the chat.
Yeah.
So from the chat, what is the standard for credible evidence, and what is to prevent a lawyer from accusing another lawyer to try to gain an advantage in litigation? And then part two of that question was as to the question of dishonesty, when opposing counsel misleads or lies to another, does that rise to this reporting standard?
Well, I think the rule is pretty clear. It says involving dishonesty, fraud, deceit, reckless. So your question turns on dishonesty, the question whether the lie being expressed is dishonesty. That is a judgment call that you must make. On the hypothetical, it sounds like it would involve dishonesty. And I'm assuming it's not just that gray area where litigants are disputing what the facts are in a case. But if it's a blatant, lie, then I think it falls under dishonesty, and this obligation is triggered. I think that answers the question.
Thank you. Erica, you said there was other questions as well?
Yeah, one more question. Is a lawyer bound to report to the state bar a violation of a rule of professional conduct? There can be differences of opinion what a rule violation is.
Well, I think that's a good question. And if there are differences of opinion, it would probably behoove you to get an opinion to clarify exactly what that is. Just like judges go to their ethics committee and they get opinions as to whether or not conduct rises to the level that needs corrective action, you may well be advised then to get an opinion as to whether or not that is a rule violation mandating compliance with this reporting rule.
Judge, was there comments in the rule with regards to the seriousness of the offense? So lying about running a stoplight versus, I don't know, so like burglary or something like that, right? It's just something more serious. Is there some level there in terms of what kind of dishonesty?
Well, the rule makes it clear that it's any criminal conduct that involves dishonesty, deceit, or reckless or intentional misrepresentation. So technically, if you're talking about a lawyer who gets caught in possession with marijuana, which is charged federally, it's a crime federally, I'm not sure that is what this rule contemplates, that would trigger any kind of reporting requirement. It probably everyone could agree that that's not significant and doesn't reflect on your honesty. But that you'd have to go case by case to decide whether it is that type of conduct that is encompassed in this very broad and far-ranging rule.
It is very broad. And then I do want to ask again, it's not just criminal acts, right? It's committed a criminal act or has engaged in conduct involving dishonesty, fraud, deceit, or reckless or intentional misrepresentation.
That is correct.
Yeah. Right. So we'll see how this all pans out and if there's going to be some changes afterwards. I think we're getting to the end of the time on this one. Is there anything else that you wanted to finish up with, Judge Baskin, here on the rule and the new rule?
Happy to take any other questions that might arise.
All right. And then, so for anyone else who has questions, you can either use the Q&A or the chat. And then we'll also have an opportunity at the end of this discussion to do a larger, more general Q&A as well. Okay, so we are moving now to Judge Austin, and we have some questions in terms of basic civility. Why is it good? Why should we be civil to one another? Can't we just be jerks? We're paid hired guns, and shouldn't we be going up and beating up everyone? Judge Austin, what are your thoughts on this?
Well, you put it that way, I guess you should. I don't know. No, there's a lot of reasons to be civil in your practice. More than I could really count and set forth for you. The first is it's in the oath. A lot of lawyers still don't realize that the oath was changed about 6 or 7 years ago and added additional language in it that says that as an officer of the court, I will strive to conduct myself at all times with dignity, courtesy, and integrity. There have been some case authority where judges are pointing towards that as some requirement that may mean that they could either report or take action if you don't follow that part of your oath, which is interesting. It hasn't really gotten to that stage yet, I don't think, but it is something that I think may be coming. Since it's in the oath, everybody's required to do it. I think another factor is the judges want it and the judges like it. So if you have any of your cases, the judges are actually required under Canon 3B4, 2, and I'll read it, the judge has to be patient, dignified, and courteous, but the judge also shall require similar conduct of lawyers. So the judge is under an ethical duty to require that all the lawyers behave themselves and are courteous to others in compliance with their oath. You put the judge in a bad situation when you're behaving badly and not in a way that's civil in front of the judge, in your papers, in anything that you do, because it does require that we take corrective action if we see it. So you don't want to have that happen. It's the last thing you want. Plus, judges always respond better, I think, when people behave professionally and civilly, and it just makes sense. Next, your reputation. Contra Costa is a small place, and we're separated up into practice areas. Word gets around really quickly if you don't behave honorably, or if you're dishonest, or you're mean to people and rude. That reputation can stick with you, and it's easy to get the reputation even with just a very few times of being out of line. The lawyers all talk to each other. In court staff talks to each other, judges talk to each other. Word gets around if you're behaving badly. And when that happens, it makes your life even more miserable, more difficult to get your cases through the courts, more difficult to reach a settlement. People are always wary of dealing with you. And it just doesn't make any sense to do that at all. On the converse side, if you behave civilly, people like to be around you. You get more referrals. You get popular with the other attorneys that are active in the bar, and you're thought of better. So it makes complete sense to behave in a way that is civil and courteous throughout your practice. Another one, just one last one before I go, because it's important to me, is it's better for you and your health and your mental health and a physical health as well. Law is a very stressful thing to practice. I don't have to tell any of you, you know it. It's nature of it is stressful. And if you make things more stressful on yourself by being difficult to people all the time, it causes you even more problems. When I was a young attorney, I noticed I was having trouble with some of the my kind of the middle attorneys, guys who've been around for a while, but I was getting along with the older guys really well, ones now that are my age. I'd get along with them. And I remember being at a deposition and asking one time, hey, how come I'm getting along with you so well, but I'm not getting along with other people? And it seems like the older guys I'm getting along with better. And so he looked at me and he said, why, the jerks all die off young, of course. And I remember that. And it's funny, after seeing now on the bench all this time, people that have the reputation for being difficult, always arguing, always trying to get over on somebody, those are the same people that end up having the drug and alcohol problems. They're having problems in their personal life. They're having problems with health. It may well happen that they end up going early. And I have seen that over time, and it just feels that way. People that behave, and you can imagine why. If your whole life is trying to get over on somebody and you're always arguing with something about something you don't need to do, it's got to increase the stress and the way that you deal with not just your professional life, but in your personal life as well. So that is really important to me, because I know I have seen it on the bench over the years.
So serious, of course. We always think about, being really active and good, zealot kind of, good, forceful litigators, but certainly you have to think about the health part as well. Do you have any tips for people in terms of staying civil when your opponent is not, and it's a really stressful situation?
That's a hard thing to do. I know it is, because boy, you just want to go right back at the person. It just is one of those things, no matter how. I've seen it a bunch in court over time, where one side's being difficult, and then the other side that usually behaves very civilly just loses it and ends up going back, and then it's hard to get the conduct to stop. But it's very important not to. I always like to think of it this way. I think it was my dad told me one time, you don't mud wrestle with a pig, because you're going to lose. You get to get muddy, and the pig likes it. People that behave badly in litigation, they're really good at behaving badly. They do it all the time, and they're used to it. If you start to try to match them, bad conduct for bad conduct, you're not going to win, because they're much better at it, more comfortable being that way.
But what happens when the other side, and maybe you're in a meet and confer on a discovery, and they're like slinging all sorts of lies about you and saying untrue things? I think sometimes us as the attorneys we're afraid that the judge is hearing just kind of one side of it. Is it better to deal with it in terms of I disagree with everything that you've said, or do you really want kind of a point by point counterpoint to the lies that they've said? And actually, I'd like to hear from Judge Smith and Judge Baskin as well on that one. In addition,
I think you want to be as direct as possible, but at the same time, you got to get yourself removed from getting involved in a name calling situation with the other side. You just want to state the facts, nothing but the facts, and move on. And the judges, as a judge, we see through all that stuff. We really do. And it's important to remember that people that do all that, at the end of the day, you're going to, if you're civil and you behave well and you're professional, you're going to do better than them at trial. They have a hard time going to trial because the juries see right through that kind of behavior as well. What do you guys think?
Judge Baskin?
I agree with Judge Austin. That's exactly right. I think you've got to just stick with the facts. Don't raise your tone to that level. Don't stoop to using words or calling names. I think that really denigrates your position. Lowering your argument level to the other side when they do that is, I'd say don't do that.
Yeah, I would agree. It's always better to take the high road, because I think in the long run, you will be perceived by the court and everyone involved in the case as being the more honest person. And ultimately, that's what's going to serve you. As a judge, just trying to sort through the back and forth of lawyers, it's difficult, it's time consuming, and it isn't productive. So if you are in a dispute, just say you're in a written dispute, you have, emails, and so then you send to the judge a series of emails, and he said this, she said that. The judge is just going to see a dispute they don't want to deal with. And so sometimes it's better either not to respond or just simply ask for what I called an independent conference, where a judge may give you an opportunity to have a conference at which time the judge can sort through the facts and decide if a decision needs to be made. So there are a lot of ways to deal with it, but I would say that the person who is most direct, most honest, and most concise about simply stating whatever the issue is really going to be ahead of the game.
Do you think it's something that we should proactively bring up to the court if the other side's being a jerk, like in a CMC hearing? Is that the time to address people's incivility?
Well, I mean, I think that it's difficult to sort of referee or mediate that kind of relationship problem in a case management conference. Usually, if there's real tension with lawyers, before the case management conference what that is, because there's either been some correspondence or some issue regarding some law in motion issues, or just in the course of the litigation, you may have an idea that the lawyers are not getting along, but sort of trying to mediate it at case management is difficult, if not impossible, and I don't think particularly productive. However, I have been proactive in many situations and just sort of counseling the lawyers that I don't tolerate that, so don't do it. Not only in my courtroom, but in the course of litigation, it is just not going to work to their benefit. Hopefully, that kind of admonishment will, carry some weight with the lawyers. But I think that's sort of the extent to which the judge can really get involved in and be effective in any event. I mean, you can do a lot of things, but what's going to really be effective may be something, a different question.
Thank you,
No,
Judge Austin.
I wanted to, one thing I wanted to make sure I got in was a technique that in trying to make sure that you don't overreact to people, or you don't start buying in response and behave in a way that's not courteous or professional. When I was a judge, I worked with judges sometimes that had demeanor problems. And one of the trainings is to figure out what it is that sets you off, like triggers, things that really get under your skin. And then to think this way, you can respond either by reacting immediately to bad behavior from the other side, or you can reflect and before you respond. And sometimes it only takes a very short time when you do that. And if you react immediately, oftentimes your behavior is bad. But if you sometimes just take a few seconds reread the email that you just wrote that that's all full of exclamation points and all caps, and reflect before you send it. That type of thing really does work. It works with judges up on the bench a lot, where you all of a sudden get that feel I'm going to start doing something. I can't take it anymore. And then you go, wait a second, that's happened to me now. You just take a breath and it goes away. And it does work that way, I think, in practice. When you're dealing with a difficult attorney on the other side, you're at deposition or somebody, and they're pushing all your buttons. And just to take a breath before you react, think a little bit, and stay professional.
So don't react, reflect. That's the idea.
Yeah, it works. And if you think about it, yeah. In the judicial trainings, they have like a little devil and a little angel. There's for reflect and react. So kind of funny.
There's some good questions in the chat. One of them, and we were talking about this when we were doing the preparation, and talking about, being a really passionate lawyer, and especially if your clients are feeling so passionate because they've been, steeped in this litigation and the fight that happened before it actually got to litigation. And then us as the attorneys were in there and trying to, channel that and also find a resolution at the same time, or prepping our cases for trial. So here's one question. Do you believe that juries are more prone to listen to lawyers who are passionate about their case, even if you might find them to be abrasive? I guess there's that question of abrasiveness bordering on incivility. What's, where's the line there? What's the thoughts there, Judge Austin?
Well, I think being passionate about your case is very effective. It's a good thing to come off that you really care about your client and you care about the case. But there's a line when if people are behaving badly in court, interrupting the other side, belittling the other side, that type of thing, the jurors don't like that. It turns them off right away. I've got plenty of stories about seeing that happen before, and jurors making comments about it in the court. Passing me notes. Why is that lawyer acting so bad? I mean, things like that that happens. And boy, the last thing you want is that to happen to you. So there's a line, and it's you kind of know it when you see it. But passions is good, but being discourteous or abrasive and just mean, it doesn't work. Nobody likes that.
Judge Smith or Judge Baskin, comments about passion?
I agree that passion is really useful thing. I don't think you can act it. I think if you have that feeling, the juries will know that. I don't think you have to raise your rhetorical level to abusive levels in order to show your passion. I think it can come out in the way you select juries, the way you do your opening statement and your closing without lowering your level to incivility.
Judge Smith.
Yeah, I think passion and incivility are two completely different things. So I think that the person who is the lawyer who is passionate or the client who is passionate, that's just a natural part of who they are and how they feel about their case. And I think communicating that to the jury is fine. Incivility, I think, is something very different. And I think acting is actually something even different from that. Lawyers who are not themselves and sort of put on an act, a jury can see that. But I think people who communicate naturally the way they are and express how they feel about their case and the commitment with which they feel that, then, I think juries will also pick that up. But I do think that there's no reason to act uncivil ever. It just isn't. And so how you feel about your case, it doesn't really play into whether or not a lawyer chooses to be civil or not.
So we can be passionate and civil at the same time. I like how that can work. Okay, good. I do see that there are other questions in the chat. We're running out of time on this section, so we'll circle back to those questions in the general Q&A when we get to that towards the end of our program. I do have one more question, though, Judge Austin. How can an attorney be proactive in establishing the two-way civil relationship with opposing counsel? How do we actually make that happen?
Boy, personal contact right up front is really important. It's funny, since I was in practice, when I was in practice, I always try to do that. When I first get the case in, and even if I knew the other lawyer, that was great. If I didn't know the lawyer, I'd try to make contact, talk about what do you think about the case, try to find something that we have in common that we could talk about that are outside the case, try to establish a relationship as people. Because I think, especially with COVID, and there's not that kind of personal contact anymore. People kind of forget that there's a human being on the other side. And if you could get that, do anything you can to try to establish that link that, hey, you're a real person here too, and get a relationship with the attorney on the other side, I think goes a long, long way. Even people that are difficult appreciate when you reach out and try to have a relationship with them. I've found attorney, not always, but if you have an attorney on the other side and right from the beginning, you try to take, the high road, be civil with them, try to establish a relationship. Sometimes they say, oh, gee, maybe I don't have to be the mean guy on this one. And then so they act differently. I've had that happen with me before, and even say, boy, I've had attorneys say, I get along with you. I like having a case with you, and I don't always get along with people. So it does help to be able to do that. I think that's a big thing. it's good to early in the case to make sure that you're doing everything you can to be accommodating. So if you have to get extensions or depot dates, any of that kind of stuff, to be as accommodating as you possibly could be. And that helps establish that you're a person and you're trying to work through the case in a professional way with the other side too. And also modeling good behavior is always important. So even if they get out of line a little bit, if you make sure that you're behaving in a way that's respectful and courteous, I think that comes back. Not always, but it does come back, and you can help establish the relationship that way too.
I think those are really great points. We can always be very strong advocates, but also be very civil at the same time. I tend to think about the personal relationships. Remember that cartoon? It was the coyote and the sheepdog. It was like the Roadrunner type of stuff, and they would have coffee in the morning and shake hands, and then the thing would ring, and then they'd go to work and chase each other, and then at the end of the day, after quitting time, they would be still good friends. But we can all still do our really good jobs and also have a personal relationship at the same time. So all good things in terms of being civil.
Yeah, I remember very well having a very heated medical malpractice trial, and the attorneys were professional, but it was heated, and then one night everybody leaves, they close up their bag, they go, come on, let's go, I'm driving over to the ABOTA meeting, and then they get in the car and they're like laughing with each other and off they go. So it's kind of funny. You wouldn't think it, but it's important to have that kind of relationship with the other side.
Right.
They're able to get through stressful times easier, I think, that way.
And sometimes our communities are so small in terms of our industry practice areas that sometimes we'll be on the opposite sides. Sometimes you'll be co-defendants. Sometimes you'll be co-counsel. And it's all of those things. And also, when we're in litigation, oftentimes it's not an in and out, we're done in 3 months. Oftentimes it's going to be a personal relationship that we're having with opposing counsel for maybe 2 years, 3 years, 5 years, right? Do you want to be like hating each other for that long? That doesn't seem to be healthy, going back to your wellness point.
Yeah.
Okay, so Judge Austin, you also talked about reputation. So I want to turn to Judge Smith, actually, who had a bunch of thoughts in terms of what is it about your reputation, and what do you do if your partner or manager wants you to behave badly? And talking about the responsibility of management and charge of the culture. But Judge Smith, can you talk about reputation?
Sure, be happy to. So when I talk to young lawyers, and I think this message is probably communicated to not just young lawyers, but all lawyers through their practices, that your reputation is kind of what you come with and what you leave with. And so you have to take care to behave in a way that lets the community in which you are working know that you are a trustworthy, honest, and civil person. So in the context of civility, you have to be careful to know that how you behave in every aspect of litigation, frankly, even in your context within the community at large, is really important, because lawyers aren't just talked about among lawyers. You are a person in the community at large. So people who may engage you, people who have maybe used your services, who may or may not recommend you. There are lots of contexts in which lawyers are evaluated. And so keeping in mind, sort of as a baseline, that when you are practicing law, it's your reputation, your personal reputation, that is always on the line. And I say that because depending on the organization with which you work, people talk about law firms, but it's any organization. The culture in the organization matters. So I know one of the questions that we talked about was, well, what happens when you have lawyers? And we talked about it a little in the context of young lawyers, but again, it isn't just new lawyers, young lawyers. It is a person who is practicing in a culture, and the expectation is that you are pressured to behave in a particular way, and or in an uncivil way. And what do you do? Because if you choose to follow that directive and perhaps act in an uncivil way at their direction or expectation because you want to make partner, you want to move up, you want to get a different assignment or better assignment or whatever, then I think that puts you in direct conflict with what is that going to do to my reputation? So my thoughts are that there are a couple of things. When a person when you're working for someone who expects you to behave in an uncivil way, I think that is something that it's difficult. It is not easy, but I think you have to address it with the person in charge and evaluate first the culture in which you're working. So if your partner, if the person with whom you are working expects you to go to a deposition and do the Pitbull Act or go to court and behave in a certain uncivil way to other lawyers, I think it's up to that person, whoever they are, to question that. There may be a person in management who is responsible for that, to whom you can speak. Maybe not, but if there isn't, you still have to challenge with whoever you're working, idea that being uncivil is really the way to represent your client best in that context. It may come to a point where you feel that the culture, if that is the expectation, that is uncivil behavior, may not be the culture for you. That may not be the place that you can work. That may not be the place in which you can be most productive or in which you can practice law effectively and still, again, maintain a reputation that's going to follow you through your career. I think more broadly, starting with the barrister section of most bar associations, sort of always communicating to newer lawyers, which is generally what the barristers are, of what the expectations are and what the peer pressure will be to act civilly and to behave in a way that reflects well on you and your organization is really important. I think the bar associations at large should always have MCLEs like this, where the emphasis is on being civil, sort of restating the requirements of the state bar and the canons that will guide them in how you are going to be expected to behave. And if you don't, sort of what the consequences are. So I think it's important for the bar associations also which I think communicates to organizations about what their culture ought to be and may be helpful in sort of creating a broader civil culture in the practice of law. Sometimes I think too that when lawyers, the expectation of lawyers to act uncivil may be a client expectation. So if somebody is asking you to do something, you might, and you're the one who's going to behave in a way that makes you uncomfortable or you feel is uncivil, before you do any of that, you may sort of ask, what's behind this? It may be that a client who doesn't know the expectations of being civil, it just is not okay. Too many TV series where behaving badly is sort of acceptable, if not, dramatized.
Mm-hmm.
So sometimes I think just if it's the client, sort of trying to deal with it at that level, sort of setting client expectations that this is what we have to do. We're going to be zealous in representing you, but being uncivil or the expectation that I'm going to put not only my reputation, but perhaps my license in jeopardy, because if I behave this way, then there may be an obligation to report this behavior. So sort of explaining it to the client who may have that expectation may take care of the problem. Go ahead.
I think it's so important what you just said in terms of when you're a junior attorney, when you're just starting out, you're a baby lawyer, and your partner or your supervising attorney is telling you, you better make sure that we're dropping this on them on, Friday evening, last moment, or that their oppositions are going to be due over the holidays because we're going to make their lives miserable. And the partner's explaining to you that it's a litigation tactic. And so junior attorneys might think this is the way to best practice and eke out, a competitive advantage here. And then, it's important for them, and this is what you're pointing out, is if you talk to other people in the bar association or your peers, that this is actually not the way to behave. This incivility is inappropriate And actually, it's in our model, it's in our rules, right? In our local rules. I think we have those in the handouts, both at the Contra Costa one and then the ones from the LA County as well, in terms of granting continuances, right? Accepting electronic service, although now we have the whole COVID electronic service thing, making sure that you're not dropping papers on major holidays or taking advantage of people when they're on vacation or things like that. Those types of behaviors are inappropriate. They're not civil, right? Even though it might get you or your client, a competitive advantage in litigation. Is that really the way that we're supposed to be practicing law here?
Well, I think that's the reason why the message really has to be come from the bar community at large, where the message is, and the bench, because I think it's the party shouldn't forget that. Well, okay, you may do this uncivil thing, whatever it is. It's a litigation tactic of one sort or another. But if you go to the judge and the person is reasonably saying, I can't do this because it's I received it too late. I can't prepare a response. And the judge sort of looks at the person who's behaved uncivilly and say, "No, I just spent a half an hour undoing a mess. I didn't need to. And yes, you may have 10 days." Then you realize that judge has a particular impression of you, and it's not good. And if that's the judge, which in most courts, there's single assignments, it's the judge you're going to be dealing with through the entire litigation. There you have it. It's not a litigation that was worth a tactic that was really worth using, because it didn't get you where you wanted to go. It sort of damaged your reputation. And, then what do you do? And the thing is, I think with meetings like this, lawyers will know that, the expectation of judges is that you do behave civilly. There isn't going to be a good outcome if you don't. That's why I think continuing to send the message in forums like these, that those kinds of tactics are not acceptable and won't work, is probably the best way to sort of diffuse those problems and to perhaps influence cultures where that is, expected. So, I think that also the judge can be helpful, and is very likely to be helpful. I think we all are, and sort of setting the tone and letting the litigants know that whatever it is you were thinking of doing, don't do it if it's going to, because it's time consuming. That's the other thing. It's not only a bad idea, but what happens is that you end up, wasting time, everybody's time. The thing that can be done more efficiently and civilly suddenly takes twice or three times as long, and nobody is served by that kind of thing. I also think, and it should be mentioned, that when lawyers, whoever they are, feel that they are not being treated fairly by court personnel or the judge, that they also have to address that and bring that to the judge's attention if it's court staff, and perhaps find a way to talk to the judge about behavior that they feel may be uncivil from the bench. It may be a misunderstanding, it might not be, but I think that it's also important to note that uncivil behavior can come from a lot of places, but it also always has to be addressed. I think that sometimes and I would suggest that if a practitioner feels that they have experienced something in the courtroom, bias, uncivil behavior, it can be a lot of different things from the court or any member of the court, that it is important. I know that as a judge, my expectations of my staff would be that they would, that would reflect the court. So they have to behave in a way. If that doesn't happen, I would like to know about it. If somebody wants to take issue with my own behavior, then I think that it's fair to approach. The judge should be approached, and that person should feel comfortable expressing how they feel. Maybe not in open court. I think you probably want to try to have a person-to-person conversation. But I also think that it's important to know that there are avenues for redress. And if a judge is unwilling to listen, then approaching the presiding judge, that's the presiding judge's job, is to address those issues if litigants and lawyers don't feel that they're being treated fairly by the bench or even staff. I mean, that a judge won't manage their staff. It's the presiding judge's job to address that, and the presiding judge has to take that very seriously, or the presiding judge can be disciplined. So I think it's important to know that there are avenues for addressing behavior in a lot of ways, but that it should always be addressed. The context in which it is addressed sort of be careful how you approach it. Just because I think if you're talking to another lawyer, turning down the temperature, as Judge Austin mentioned, sort of the context in which you address it and the way in which you address it would depend entirely, on how effective it can be. And that's the same thing with approaching the court. Sort of decide what's the right time, what's the right way, giving the person to whom you are speaking the benefit of the doubt, to just try to reach consensus about, resolving the problem and moving on, because ultimately you're all there to do a job. So you don't want to do things that hinders anyone who's involved from doing the job.
Thank you. And so you talked about if an attorney feels that there's maybe they experienced bias from the court or the court personnel, but what about if the attorney felt bias from their opposing counsel? Do you have recommendations on how they should handle that, and if it's with the court?
Well, I think the first avenue would be to address it with the person, and I think Judge Austin touched on this a little bit, in that when you are experiencing something, you have to decide how you want to address it. It couldn't be in the moment, and maybe something may need to be addressed in that moment. But if it's a heated situation, you may want to step back from that situation before you try to have a larger conversation about being treated in a particular way. You may have a problem in the moment that needs to be addressed in a deposition or something. You want to get past that and finish the deposition. You may need to step back and calm down, or the person who needs to address it, to decide and articulate very clearly and without sort of invective and what's the problem? This is how I felt when you addressed me. I didn't like it. I felt that it was biased for these reasons. And I'm telling you this because I think we need to resolve it. Now, it's on the other person to respond to that. But I think that that's the first avenue. I think that often those problems can be addressed in that way satisfactorily. If the best ways, of course, I think, to start out having a relationship so those things don't happen. But, sometimes, you meet somebody once, you're not in a relationship, you're just meeting them for the first time, and they say or do something that's really offensive. So I think addressing it directly, if they don't respond, then there's someone else in their organization you may need to go to report this behavior. It may rise to the level of reporting it to the bar. I don't know. I think that's one of those discretion things that they have to make a decision. Is that the kind of thing that gets reported or not? Or is it something that can be addressed outside the context of sort of seeking some sort of disciplinary action? But I do think that sort of addressing it in a way that articulates clearly what your concerns are and gives the person an opportunity to respond is the best way to just initially approach it. And then after that, depending on the answer you get, it may be resolved. It may not. And if it isn't, then you may want to take it up the chain to whoever else in the person's organization to say, this is unacceptable. This is something that I experienced. I don't like it. I don't have to tolerate it. And something needs to be done. So that's I think how I would suggest someone address it initially. Yes.
If you're in litigation too, you could always, and I've had it before, be addressed like during the course of a motion or something else, even at case management. The attorney would bring it to my attention that something's happened where they believe that they've been subjected to bias from the other side, and we as judges under our ethical rules have to take corrective action. We have to take appropriate action when that happens. So and if it could be just a discussion with the attorneys back in chambers, it could be, different things that you could do, but I think it can be helpful.
Thank you. There's a question in the chat, and this is to any of the panelists. Is there a published procedure to address the types of issues that Judge Smith is speaking about? And then they ask specifically here in Contra Costa, but I would imagine whether it's Contra Costa or Alameda or any of the other jurisdictions that you might know about.
I'm happy to address it for Contra Costa County. I think the question is referring to conduct either by the judge or by the opposing counsel. And is there a procedure that's published? I'm understanding the question to be that. And the answer is there is no procedure published. And I think Judge Smith and Judge Austin have referred to that, which is you can take it up directly with the judge, and you can do that in writing or in some other way. But if that fails to satisfy you, you can take it up with the presiding judge. That's typically done in a written letter addressed to the presiding judge, who is under an obligation to review your letter carefully, investigate the facts behind it, perhaps even looking at the transcript of the hearing that you are referring to, if there was a hearing that was involved, and then taking the appropriate corrective action with the judge, if it's the judge that's concerned. If it's the opposing counsel that you're dealing with, there's the only procedure that I'm aware of is the one we're talking now, which is Rule 8.3. That's the reporting requirement that's applicable to what we're discussing.
Okay, thank you, Judge Baskin. All right, moving along. We do have, one more question, Judge Smith, about mediation and what advice you would give to attorneys who experience incivility during mediation, because sometimes the attorneys put on a show, right, for their clients, and they yell and rant and rave, and they really want to show their clients like how passionately that they understand that their client feels passionately. They've been living with this injustice for so long. And so then they, start behaving what might kind of pass the incivility mark. And they take extreme views and dig in their heels. And how should attorneys on the other side handle this?
Well, I think that in the mediation context, the parties are rarely all in the same room. So you're really not getting the same dynamic where in the courtroom where everyone is arguing to the judge. I have not yet had a mediation where the parties were in the same room. So I'm usually with one party, from pre-mediation through mediation. So on Zoom, you're in two virtual rooms, 3-4 virtual rooms, but you're not in the same virtual space. Physically, if we're at the ADR offices, you're on opposite ends of the building. So that kind of thing isn't going to happen. What happens, though, is that when a lawyer is, and I'm with a lawyer and his or her client, and we're talking about the case, we're talking about sort of strategy for how they want to mediate the kinds of offers or responses they want to make. And I think a lawyer gets a little out of pocket. I have asked to speak to the lawyer separately from the client, asking their permission. Generally, it's fine. And having a quick conversation with the lawyer usually resolves the problem pretty quickly. I rarely see this, by the way. Mm-hmm. It is not often that I see in mediation someone who acts uncivil in that way. I just really rarely see it. So I've only had to address it once or time. And sometimes it's tone. It's so, maybe I'm not sure it rises to the level of being uncivil, but the stuff that's not productive, you really want to address with the parties or the lawyers. I mean, so you're thinking about how are we productive in the time we have to address this, to try to resolve this case. So that kind of thing just takes up time, and it's not productive. So if I need to speak to a lawyer, or if I need to take a lawyer aside or put them in a breakout room to say, maybe you can talk to your client about his or her behavior, because sometimes it's the client, and say, if you could just have a chat with your client, because I think they're sort of off on the wrong path in terms of how they're viewing this or how they want to respond. This isn't going to be helpful. I don't generally deal directly with a client's behavior. I think that's dangerous. So I've usually allowed, ask the lawyers sort of when that comes up. Again, it's been so rare that it's kind of hard to say there's one way or to deal with it. But I think just dealing with it head on and separately, in a separate space where you can sort of suss out what it is. Sometimes lawyers do things and they'll talk to you separately and say it's a client problem. Help me. That happens. Yeah, no, that's happened more though. It's help me. Can you help me? And then I know what the problem is, and then I know how to address it. And then sometimes it's just somebody gets carried away and you just sort of try to calm the waters and then kind of keep moving. I mean, ultimately, you just want to remind the parties that we're here to try to resolve this case, come to consensus and sort of get them back on track to that end.
Thank you. And we're kind of moving into the effect that civility has on ADR, and just in terms of either the general process or how attorneys behaving badly towards each other and how that affects the mediation process and affects the mediator. Judge Baskin, Judge Austin, do you want to comment as well?
Steve, you go ahead.
You see it sometimes. It's funny. I think I see it more since I've been mediating cases than I did when I was on the bench doing settlement conferences. And it could be just the gravitas of the position there is different, and so people don't express as colorfully how they feel about the other side when you're back in negotiations. But at mediations, they do sometimes, and it's kind of difficult to what to do with it. And I think what Judge Smith just said about how it's sort of a waste of time, that's a good way of thinking about it. And so I've been trying to sort of redirect. Let's get back to the facts of the case or something like that. Well, what about this? And I'll come up with some different tasks that we need to do to think about their case in a different way, so that we're not just dealing with kind of insulting the other client or insulting the other attorney. And that works pretty well usually. Sometimes they just need to get things off their chest a little bit too, and so I try not to be too heavy-handed when people are doing that, especially in the pre-mediation calls. Sometimes they're trying to set the tone and set the expectations of the other side, and it's difficult sometimes when people are really starting to be insulting. I've said before, that's really not helpful. But let's get back to the facts. That's a good way to do it, but it's a technique I used when I was on the bench. That's not helping me get this case settled, or it's not going to help me do this to go into that. And that works pretty well too. But it is out there. So as attorneys in mediation, you're making the mediator's job way easier if you don't get into any of that kind of thing, insulting of the other side or the attorneys or the client themselves. I mean, we like to know some things that are happening that are difficult, an insight you have into the thinking of the other side. But when you get kind of petty or it doesn't help the process at all, or make it more likely that the case is going to settle. So your ultimate goal is not reached.
Yeah. The only thing I would add to that is that I typically do my mediation separately. And so if someone is being uncivil and giving me that information, I typically don't stop that, because to me, that is useful information. It might be informing me about why the parties aren't connecting to begin with. It might be telling me why they're here, using me to try to get to a more objectively fair result because they're miscommunicating that way. So I'm very loath and hesitant to correct that type of uncivil references to other counsel or the other parties, because I find in that uncivil behavior, there are nuggets that can be gleaned as a mediator that are useful. But there's a line, and I agree with Judge Austin and Judge Smith, that there's a line that can't be crossed. I just haven't seen that yet. I haven't had that line crossed yet.
Thank you,
And,
Judge.
in that regard, Judge Baskin, you raise a good point, which is you don't want parties to not think that you are not communicating with them or establishing a rapport with them. So I guess I don't want my point to be mistaken as a corrective. I never correct. But there is a point, and I think sometimes when you're getting to the point where it's not productive, because now you kind of have the information you need to guide you in terms of who you're talking to. But if it sort of borderlines on the insulting and the the pejorative, then I will redirect. I mean, that's really my strategy, is to just redirect. I never correct, because you also don't want them to feel they can't communicate with you, and you do
Mhm.
need all the information, and you want their trust. I mean, people hire you because they don't have to hire you, so you want to develop trust with everyone in the process. So I would hope that no one would interpret anything we're saying to suggest that, we're there policing behavior. We're not. But sometimes behavior, if it's not productive, then you want to redirect to productive behavior. And how you do that is, very carefully, very carefully.
Do you think that there's a difference between in-person versus virtual and effects on civility?
I don't.
I've
I
kind
think
of
people
found. Oh, go ahead. I'm sorry.
I was just going to say, I find that people in person, it can be a little more tense than when we're mediating virtually, but I don't think it really impacts civility. I haven't seen it.
Judge Austin.
I think it's funny. I don't know in mediation how much it there's an impact one way or the other. I know sometimes doing court appearances, and when we were doing everything on Zoom,
Yeah,
I think people could get a little more out of line on Zoom than they would in person, because the person's not just standing there next to them; they're just Brady Bunch faces on the screen, and I think sometimes you lose some of the humanity when that happens. You notice it kind of in mediation too, not so much with insulting behavior, but I think not recognizing what the other side's thought processes are as well, because they're not really there. It's hard to deal with it when you're in the same building and you see them walking around the halls, even when you're in different rooms. It's a little bit different dynamic than it is when each one goes into their breakout room and they never see each other the whole way through. I think behaviors sometimes are better when you put a person behind the little face on the screen.
Thank you. Judge Baskin, any thoughts on virtual or in person?
Well, I don't notice a difference in the behaviors, but I think that personally, I prefer in-person mediations, not because that it affects the civility of it, but I think people are more invested when they are present in person than when they are in Zoom. But that's just my personal view.
Sure, that makes sense. We are running close to the end here, so I want to get to the general Q&A, and there were some good ones in the chat. Let's see. There's one here which says, depositions are a difficult situation because the other lawyer's incivility may keep you from getting questions answered, kind of like the video that we were saying at the very beginning. How much line do you think you need to give your adversary before asking for judicial intervention? That's a good one. Who wants to take that one?
I'm happy to take it. I think it's a judgment call. Everyone has to make a judgment call at a deposition. You've got to try to minimize going to a court asking for, a discovery motion. I think judges don't like that. Typically, you have to go through a discovery referee program. If it's really problematic, you end up with a special master being appointed. So I think it's a judgment call, and I don't think you can come up with a hard and fast rule. But definitely, if it's that type of behavior that we were witnessing in the video, you would want to be bringing a motion pretty soon.
Thank you. This one looks more like a comment, but it's a good one. There is a way to be civil and quote unquote tough, passionate. In a recent article in the New York Times on Fannie T. Willis, it was reported that she had written to opposing counsel, quote, "You mistake my kindness for weakness." So there's a good thought for all of us to think about. There's another one. How does a lawyer address a judge when the language is by body language and tone disrespectful to a lawyer? How does one speak to a judge without alienating the judge?
That's a tough one.
Yeah, that's hard. I think that if someone is sensing body language, that's sort of an interpretive thing, which I don't know if you're in open court. You're going to be able to have that conversation. And I think that if it's a one-time appearance, you may not really know who that judge is. And so what you may be perceiving as body language that's problematic may not be that. If you consistently get that from a judge and you do feel that the judge is communicating something that you feel is biased, I think having a conversation with the judge directly, I mean, when I say directly, a face-to-face, ask to speak to the judge, ask the opposing counsel, if you're in the middle of litigation, may I speak? It's about something not related to the litigation, and just having a conversation with the judge and telling the judge how you're feeling about the way that person is treating you. Then I think that's the thing I can think of that you would do. But I think it's also effective because most judges are receptive to that kind of feedback. They want to know if there's a problem. They want to know if the parties feel that they're not being treated fairly. It may hurt, but we're big boys and girls in our row. I mean, that's our job. Our job is to take that criticism and do something with it positive, including apologizing if in fact that's necessary. Like, I'm really sorry that happened and it won't happen again. So yeah, I think that just dealing directly with the judge in a setting where you can actually have a conversation and express yourself in a way that really communicates it to the judge, then I think that that's what you should do.
I think we all want to know if someone is perceiving that we're being disrespectful to them by our body language or by our conduct. I think it's important because a lot of times the judge won't even realize it. They won't think that that's that, and they don't realize how it's being perceived by other people. And we all want to make sure that the way that we're behaving makes people have trust in what we're doing and the process. So I think it's important if you're feeling that way, to let the judge know.
Thank you. Judge Baskin, this looks like it's a question for you in the Q&A. Who resolves complaints made to the state bar? And the question was, is it state bar court judges?
It's my understanding that the state bar investigators are in charge of the intake of complaints. And when they determine that there's merit to the complaints, they open a case. And that case goes to a hearing. And at that hearing, the state bar judges do conduct that hearing and make decisions.
All right, thank you. We have a little bit more time, and if we have maybe personal stories or anecdotes, Judge Austin, you would kind of maybe read reference to a few thoughts or memories that you had of maybe people behaving in, uncivilly, whether it's in mediation or in court, and maybe how you handled that.
I can't think of one off the top of my head now that you say that.
Spotlight's on. Anyone else, Judge Smith or Judge Baskin, any sort of personal stories of maybe people not behaving the best that they should have been and really uncivilly?
Well, going to the question that you had, I, as a lawyer many years ago, had a matter where I was the prevailing party in a summary judgment motion. The opposing counsel requested oral argument. After about 5 minutes of the judge telling opposing counsel that there was going to be no change in the tentative ruling, counsel continued to belabor the point, and the judge swiveled the chair around 180 degrees. So turning the back to the lawyer. So the lawyer put on the record, the record should reflect, Judge, that you have rotated your chair 180 degrees, and that tells me you're not listening. And it's very disrespectful of me making this argument, to which the judge rotated back around and said, I'm listening to every word you say. I'm rotating myself around so that I can have extra patience with your belaboring what I've already addressed and told you not to address. So,
he was reflecting, or she was reflecting.
Right. That could be a reflection.
Right.
Oh, I don't know, Barry. That's the best story. I can't top that one.
I'd seen some things, a long time ago. There was this one situation, we were in a settlement conference in one of the rooms. It was over in Alameda, and it was an older male attorney, and he was very tall. And there were a bunch of defense counsel. And then there was the other side, and it was a younger woman. She wasn't like newbie. And he like physically came up and towered over her and yelled at her and called her all sorts of personal attack names. And, and it was just really uncalled for behavior. And I told him as much later on, which didn't win me necessarily any brownie points. But, he really needed to be told that he was out of line.
Yeah.
But certainly using it as a technique, right, in terms of a litigation technique to intimidate that attorney. And she wasn't intimidated. It didn't change the settlement. And, he tried, but it really wasn't effective. I think, once you cross the line and start making personal remarks about people's appearance or pejorative names, whether or not that's to their face or not, that's just really unacceptable in terms of, attorney behavior. And I don't care what kind of settlement that you're trying to get, it really shouldn't go down that route.
Yeah. I think it's important. I remember one of my first bosses told me, always remember that when you're getting embroiled in one of these cases, this isn't going to be your last case. And that, in fact, you're going to have thousands of them over the course of your life. And you don't want to set yourself up by doing something bad, in this case, to have problems later. You want to stay every case above board and behave in a way that's ethical and civil to people, because the other path just goes nowhere.
Right. So we are coming up on time. Do we have any last words of wisdom from our panelists?
I think I would just simply say that, if you behave in a civil way to opposing counsel, to the court, and to pretty much everyone involved in your practice, then it goes a long way. And you don't have to deal with all the other things that come with not being civil, the potential reporting of your conduct, the potential problems that you may have in practice later on, the damage to your reputation. And so I really do think that just sort of reinforcing not only your behavior but your peers it can help you, in your practice and in your life. As Judge Austin pointed out, nobody needs that stress, frankly.
Judge Baskin, Judge Austin, anything else to add? Oh, Judge Baskin on mute. Sorry about that. I don't know if I can unmute you. I don't think I can.
Sorry, I don't know how that came
about. There you
go. I was going to say that you've all witnessed lawyers in a courtroom, or seen them as a judge. I've seen many of them, and all the successful ones have civility in common. That is absolutely my observation, without exception.
Life's too short. That's what I say. You want to have, be professional, but boy, it's not worth stirring the pot and getting yourself into trouble and stressed out. So stay above board.
Stay above board. Treat each other well. Let's make sure that we have a good reputation and a good profession that we can practice in for a long, long time.